Good evening, everyone. Thank you so much for coming out tonight. We are absolutely thrilled to have this program at Brooks Memorial Library. I'm Star Latronica, and I get to work here every day. It's amazing.
But what makes it so worthwhile is to see all of you here. So thank you, thank you. We're especially excited to have this program on the First Amendment tonight because it is smack dab in the middle of Banned Books Week, which is when we celebrate our freedom to choose whatever it is we want to read, and libraries make that possible. So tonight I did bring, yeah, right? And tonight I just wanted to highlight one of our books we have a small display of banned books over there by Lissa. But you'll know, and this one is The Invisible Man by Ralph Ellison. And this book, Ralph Ellison began writing this book in a farmhouse in Vermont. So how about that? Mm-hmm. And you'll notice that we just have a few books pulled out on display, but our brilliant staff has peppered the stacks with books with this bookmark in it, and all of those books that you'll encounter as you're browsing have been challenged or removed from libraries. So take a look and pick out something good to read. Anyway, so we are so lucky to have in our midst Meg Mott, who's going to talk to us all about the First Amendment. And this program is brought to us by our friends and excellent partners, the Wyndham World Affairs Council, and all of the folks that you see listed on that poster over there. And Lissa Weinman is going to talk to us a little bit about the Wyndham World Affairs Council, and then we're going to get to Meg.
Thank you so much, Star, and thank you, Star, and all the library staff for all you do every day for this town. We really appreciate it so much, and I know you know we do. So I'm Lissa Weinman. I'm with the Wyndham World Affairs Council. I'm here with several other board members. If our board members could just raise your hands, Merrill and Claire and Scott and Jim Kirby. If you're interested in joining us, I would say, just grab a board member sometime after the event tonight and let us know. We can sign you up. We do depend on memberships to do monthly talks. The ones that are coming up are October 30th. We have Bob Beck talking about the state of the war in Ukraine. We're also going to be doing a salon the week before on October 23rd. We occasionally, after our board meetings, do salons where members of Wyndham World Affairs Council and some members of the public, friends, can come in. We're going to hear from an asylum seeker from Russia who was jailed in Russia for opposing the Ukraine war. That'll kind of tee us up to remember that war is still going on, and we'll hear from Bob Beck and discuss that on October 30th. But that salon will be October 23rd at 118 Elliott. And then in November 13th, we are going to have a talk on China with Mark Seidel, who's a professor at University of Wisconsin in Madison. He also is a consultant to the Ford Foundation on their China programming, and he'll talk about civil society in China today. And we have others in the audience and members of Wyndham World Affairs Council that are very knowledgeable about China, even in the audience right now, Jim Friedman, who will probably participate and enlighten us further in that discussion. We're also going to be inaugurating in October a new thing for Wyndham World Affairs Council, which will be a reading group and a teach-in on modern Middle East. That's going to start on October 20th. That's a Sunday, and it will run for 6 consecutive Sundays from, I believe it's 3 to 5 p.m. And that will be moderated and led and taught by Claire Morgana Gillis, one of our board members who has her PhD from Harvard and is very, very knowledgeable, has worked as a journalist in the Middle East, and she's going to lead that. So if you're interested in that, you can sign your name and just indicate interested in the teach-in or talk to Claire after the event tonight. And so this talk tonight, this is a town hall, America 250 Town Hall, We're doing a series of these in partnership with Vermont Independent Media and the Brooks Memorial Library, leading up to the semi-quinticentennial of the United States, which is really July 2026. So leading up to 2026, we've been embarking on this Examining American Identity and Leadership in a Changing World series, we call it. That's a mouthful, but really what we're doing is really looking at the role of the United States globally and how people have looked traditionally to the United States for global leadership and how that's being impacted by really our division and our challenges here at home today. So Meg Mott is a partner in this endeavor to really dig deep in terms of who we are as Americans and who we want to be. She terms herself the Constitution Wrangler, and we love that because she really is an expert on the Bill of Rights, on the U.S. Constitution, on these founding documents that we depend on for the conduct of our nation. Meg has her PhD from UMass Amherst in political science. She was a professor at Marlborough College for some 20 years. That's where we got to know each other. And I've been impressed with her ever since. She had a column in The Reformer, and she often writes for our local media. She's also right now got a new project developing curriculum for the state of New York public schools for 7th and 8th graders on civics, which is, as we know, really important. And I couldn't think of anybody better to be doing that. So without any further ado, I'd like to welcome Meg Mott.
Thank you, Lissa. I think I'm mic'd, so I should be okay.
I think we got you
Yeah.
right.
Can everybody hear me all right? Great. All right. Well, thanks, everybody, for coming out. I'm eager to have another conversation about the First Amendment. This one's going to be a little different than I normally do. Usually I ask a more abstract question. I think the last one we did is, do bans on homeless encampments violate the Eighth Amendment? And then we look for arguments for and arguments against, and we get to have a great intellectual activity, and our brains get to go all different neural pathways as we hold competing arguments in our head at the same time. It's all very dynamic, and maybe some of you have seen my little mnemonic device, which is, why do we get involved in the big controversies of our time and really wrestle with both sides? It's because it will get us out of the back of our brains into the front of our brains. And so the path to freedom is not that far, I say. It's like just get out of the lizard, tribal, only one side of the picture, to let's hold complexity in our head and really wonder about both sides of an issue. But my friend Amr Latif, who's not here tonight, but who always gives me his honest appraisal of whatever it is I'm doing, has tended to say I'm a little too obsessed with the law. Steve Wong, I think, has also made that point as well. Like, sometimes, Meg, you're just a little too intellectual. I think, but what about this? Isn't this fun? Let's go to the frontal cortex. And Amr says, you're forgetting something. You're forgetting about law in the heart. Law in the heart. So I thought tonight's discussion about a difficult Supreme Court case, difficult decision, could be a way for us to think about the heart a little bit more. And to sort of, it's not in the Constitution that we should be thinking through our heart. However, somebody is going to read a statement from Judge Learned Hand that makes a big claim about the heart. We'll get to that in just a moment. But the idea that the law is in the heart is an old, old idea. It's a pre-modern idea. St. Thomas Aquinas said, what is natural law? It is a law that is written on the heart. When we're really trying to figure out what is right or wrong, we look to our heart. And our heart is pretty reliable and will let us know when a certain law on the books is unright, is wrong, is unjust. I also, this is what I got from Amr. In the Sufi teaching, there's this idea that the heart is the place where you're able to see what's actually happening in the world, as long as your heart is polished. If the mirror of the heart is dirty, the reflection of God is distorted. The reflection of the ultimate being, the reflection of the big picture is distorted. But if the heart has been polished, it can reflect the guidance, creativity, and inspiration of the divine. If we polish our hearts, we should be able to see more. So I'm going to set this as the first answer to the question, and we'll see if you all, by the end of the evening, agree with this. What does the First Amendment ask of us? We have to polish our heart. We're not going to be able to do this very well. Look, this is what I got. Unless our hearts are well polished. So we can hold this on as we go through, because this is going to be a hard case to talk about, the Brandenburg decision. And yet, I think it could ask something of us that might be good for our souls. So that's where I'm hoping we'll get to by the end. But I have to make that case, and so let's start with the First Amendment. And everybody, I'm hoping, has a little brochure here. And at the back of the brochure, would somebody just be willing to read the First Amendment? And Allison, oh, look, and we can go. Would you be willing to read? Oh, no, but now I want you to read. What's your name? Meryl. Oh, you are Meryl. Okay, Meryl, would you mind reading the First Amendment?
Okay. The First Amendment says, Congress shall make no law respecting an establishment of religion or prohibiting the free exercise thereof or abridging the freedom of speech or of the press or the right of the people to peaceably to assemble and to petition the government for a redress of grievances.
Thank you very much. So there we have it. I should be able to say, okay, everybody, we've got our words, we've got our freedom, everything's fine, good to go, have a nice evening, go watch Netflix. But in fact, what happened is those words appear in the Bill of Rights, First Amendment, and immediately everybody's like, okay, that's fine, but you know in Connecticut, you cannot say certain things against, and I can't remember what Protestant sect was in control in Connecticut, but there were certain blasphemy laws on the books if you did not fit the very precise Orthodox Protestantism in Connecticut. So everybody knows Congress cannot abridge freedom of speech, but let's understand that in Connecticut, you can have restrictions on blasphemy. Or in the South, you cannot talk about abolition. You just can't do it. If you were to say it, you're going to be put in the pokey. So Congress may not be able to pass any laws respecting freedom of speech, but let us not think that there was freedom of speech in the United States, because the states had a lot of control over what could be said. So 1, having to do with religion, 2, having to do with slavery. Number 3, there's a great book. It's called Holy Shit, and it talks about how holy matters were restricted by the First Amendment, and I'll say shit again, but I shouldn't say it anymore because we don't want to get the YouTube channel in trouble with the, what is it? FCC, thank you very much. So all those words that Lenny Bruce liked to say, those were not protected by the First Amendment. So we have these words on the book in the Constitution. Everybody says Congress can pass no law, and yet there are laws on the book that restrict our speech. And everybody's like, okay, I've got freedom of speech, and as long as I stay away from the holy, and I stay away from the S-bomb, everything's fine. And I don't talk about slavery pre-Civil War, and even after the Civil War, I have to be careful what kind of things I may say under Jim Crow South. Everybody understands those restrictions. And we are having our First Amendment, and we have these restrictions, and we're okay with it. And I say we, sort of, nobody's raising a ruckus about these. And then, in the First World War, there's all sorts of people out there who have things to say about the First World War. There are communists out there. There are anarchists out there. There are socialists out there. There are Quakers out there. And these people are saying things such as a man named Charles Schenck, and he's saying, he's distributing pamphlets, kind of like this, but instead of my little pamphlet with maybe he had the First Amendment, I don't know, but in his little pamphlet that he's passing out to everybody, it says, you should not go and fight this war. This is a war that is serving the industrialists. This is a whole plot to reduce the labor power in the United States. So he passes out all these pamphlets, not this pamphlet, but pamphlets that look like this. And he gets put in the pokey because you are not supposed to say things that undermine what the government is trying to get done. So Mr. Schenck, Charles Schenck, takes his case to the Supreme Court, and this will be the first case in which we'll hear what the Supreme Court says. So if you open up your little brochure, and this says Constraints on Free Speech, we're going to get the decision in Schenck versus United States, which was written by Oliver Wendell Holmes, Jr. Now, Oliver Wendell Holmes, Jr. is an amazing jurist. He has a lot of beautiful things to say. He was shot 3 times during the Civil War. 3 times. And when you got shot in the Civil War, you didn't get hit by a bullet, you got hit by a ball. So pretty serious injuries. I want you to know I have great respect for Oliver Wendell Holmes, Jr. And what he's about to say, and I'll give you a reason to be more suspicious about him later, but we're going to hold on to this. Great war hero. Somebody who's willing to lay down his life in order to end slavery. And so after Mr. Schenck makes his case, he has this dilemma. What's he going to do? And this is probably one of the most famous decisions with respect to free speech that came down from the Supreme Court. Is there anybody in the audience who would be willing to read, there's 1, 2, 3, 4 paragraphs, and we'll get you a mic, and we'll just go through it a little bit slowly. Do I have any volunteers? Great, thank you. And are you Bob, Robert? No, what's your name? Rick, because I've met you before. You've come to one of these things back in Marlboro. Rick, yes.
So did the whole first panel?
Yeah, this panel.
The character of every act depends upon the circumstances in which it is done.
Okay, so first thing we want to know is these pamphlets were handed out during a time when they were trying to conscript lots of people into the army, and he's passing out a pamphlet saying, don't go to this war. So we want to hold on to the circumstances. Yes, thank you, Rick.
The most stringent protection of free speech would not protect a man in falsely shouting fire in a theater and causing a panic.
Have you heard this before, Rick? Yeah, this is like probably the most familiar thing that came out of the Supreme Court. So this man, Schenck, who's passed his pamphlets, is not unlike falsely, and sometimes people forget that, falsely shouting fire in a crowded theater. Yeah, thank you. Keep going.
The question in every case is whether the words used are used in such circumstances and are of such a nature as to create a clear and present danger that they will bring the substantive evils that, in brackets, the government has a right to prevent.
Yeah, okay. Clear and present danger. Something else I guess everybody has probably heard about, that there are certain restrictions on free speech. And those restrictions are, if the speech is of such a nature that it's creating a clear and present danger, just like shouting falsely fire in a theater, that's not going to be protected. And can you give us a last one?
It is a question of proximity and degree.
Okay, turns out, Mr. Schenck, this pamphlet that he was sending along, as far as Oliver Wendell Holmes was concerned, that was like falsely saying fire in a crowded theater. That's the kind of impact it had. And at the time, everybody's like, yep, those socialists, those anarchists, those communists, those Quakers, they're dangerous. They present a clear and present danger. So, okay, Mr. Schenck, off to the pokey. Eugene Debs, same thing. He gives a speech in which he says to a lot of people, he's running for president, your bodies are going to be turned into cannon fodder. That's what they want. He gets put in the pokey, charged in the Espionage Act. he says, wait a minute, this is a violation of my First Amendment. And the Supreme Court says, hey, did you read what happened to Schenck? What happened to Schenck? Same deal. You're kind of like the fire shouting falsehoods, creating a panic. So Eugene Debs goes to prison, where he gets 1 million votes for his run for presidency, but he's in prison. Anyway, he doesn't make it. So there's those two cases that go bing bang in 1919. And there's that sense within the states as well, we have to do something about all these socialist, anarchist, communists, Quakers, because when they say things, they're actually not protected, one, under the First Amendment, two, what they're saying are clear and present dangers. Clear and present dangers, given the circumstances of the war. So states start passing laws, and one of them is a criminal syndicalism. So at the very back, right underneath the First Amendment, you'll see that there started to be laws that were passed, and they're very broadly defined. Let's see. Oh, and now I want to remember your name, and I forget, because it begins with an M. Marnie. Can we give Marnie a mic? Because I think she might be able to read the Criminal Syndicalism Act. Thank you.
Prohibited advocating the duty, necessity, or propriety of crime, sabotage, violence, or unlawful methods of terrorism as a means of accomplishing industrial or political reform, and voluntarily assembling with any society, group, or assemblage of persons formed to teach or advocate the doctrines of criminal syndicalism.
Yeah, okay. So in case there was any discussion, in case there was any question about this clear and present danger and what constituted clear and present danger, criminal syndicalism statutes are on the books, and they say if there's a group of people who are getting together and their purpose is, note, political reform or industrial reform, and through that rhetoric of trying to engage in political or industrial reform, they start saying anything that could be perceived as violent, we're going to put them in the pokey. So this happens in Ohio, it happens in California, it happens in many places where anarchist, socialists, communists, and Quakers, and now trade unions, other people are trying to organize, they are going to get put in the pokey, just for their speech. It's a very, very broad statute. So then we come up, the next big case is Charlotte Whitney. She's a, what do we call them? A socialite. I don't think we use that term anymore. A member of the elite class. And she had communist sympathies. She was a member of the California Communist Party. So there she is, attending at a convention, and the people are speaking the way the communists were speaking, which is trying to get a hold of the means of production and needing to overthrow the US government in order to do that. They are advocating for political reform, and they are advocating for industrial reform, and they're reading Karl Marx, and Karl Marx makes a case for an armed revolution. So the fact that she's a member of this party, even though she's come to the convention that year in order to say, actually, I think we should go a more political route. Maybe the armed revolution isn't the best idea. And they vote her out and say, no, 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 we're still going to go with the full-fledged Marx. She gets put in the pokey for her membership. And so that goes in front of the Supreme Court. This is 1925, and we can open up our panel, and we'll find right at the center. And this is our last case in the history lesson, then I'm going to open it up to some more discussion. The last one is Justice Louis Brandeis, who writes a concurrence. He and Justice Holmes think that the outcome in this case, they can't overturn the conviction. There is nothing in the case that happened at the trial that they can overturn the conviction. But they begin to think this whole clear and present danger standard is getting them into trouble. Because really, was Charlotte Whitney's speech at the Communist Party convention? Was that truly clear and present danger and she should end up in the pokey? Nope, says Brandeis. Is there somebody who'd be willing to read some Brandeis? Steve, can I put you on the spot? Steve Wong, we did not talk about this ahead of time. He just came.
I'll just read the part you pulled out.
Okay, but you came armed with Brandeis.
I did.
Loaded. Yes.
That's because I went to Brandeis, and there's been a big fight there this year about this.
Oh, interesting.
There must be reasonable ground to believe that the danger apprehended is imminent. No danger flowing from speech can be deemed clear and present unless the incidence of the evil apprehended is so imminent that it may befall before there is opportunity for full discussion. Those who won our independence believed in the secret of happiness and the courage to be the secret, and she believed liberty to be the secret of happiness and courage to be the secret of liberty.
And I'm glad you read that twice because that's so key. Liberty is the secret of happiness and courage is the secret of liberty. Yeah, keep going.
They believed that freedom to think as you will and to speak as you think are the means indispensable to the discovery and spread of political truth.
Yeah, thank you. Okay, so what happens? Whitney's.
I'll read one more that you don't have here.
Okay, Steve, keep going.
He ends up saying,
Yeah.
if there be time to expose through discussion the falsehood and fallacies to avert the evil by the process of education, the remedy to be applied is more speech, not enforced silence.
Yeah, thank you, thank you. More speech, not enforced silence. So at this point, things start to change. Allison, are you able to get that mic? At this point, there's this new idea. Maybe Eugene Debs should not have gone to jail. Maybe there should have been more discussion about the pros and cons of the whole conscription and World War I. Maybe Mr. Schenck should have not gone to jail. Maybe people could have said, well, I don't really like your pamphlet, but I still think I want to discuss it with you. So there started to be this idea like things had gone seriously wrong with the First Amendment. The governor of California cites the Brandeis concurrence when he pardons Charlotte Whitney. So Charlotte Whitney gets out of the pokey, not Eugene Debs or Mr. Schenck. But this is the law on the books still. They did not overturn clear and present danger. They did not take away this idea that falsely shouting fire in a theater is the analog to dissident speech and therefore is clear and present danger and should be restricted. Shoshana, can you?
Where does the Smith Act? Where does the Smith Act fit into that? Because that was already in existence in the 40s, 50s. So just membership in the Communist Party was illegal, based on clear and present danger kind of.
And that is the Smith Act, if I'm remembering correctly, passed by Congress.
But when? Do you recall when?
I don't know,
Yeah,
but
I don't either.
all. There were all these laws on the books, whether it was on the federal level or on the state level. And the criminal syndicalism was one way to go about it. And then there were these broad acts, I'm pretty sure Smith Act and the Espionage Act, those were on the congressional level. And it basically said the First Amendment, when it comes to certain political speech, does not count. And Shoshana is asking, like, what is their status? I don't know. I think there's a lot of laws on the books that should be cleaned up, personally, but I don't know its status. So in terms of these Ohio criminalism statutes, and that's a specific category, they were on the state level. It takes a long time, but in 1969, a case comes along, and it overturns the criminal syndicalism statutes. So this is a state case. That's the first thing. It's not a congressional case. When you're fighting laws, if you want to fight something Congress did, you need to go through the federal, and it has to be a federal decree. If you're fighting what a state is doing, yes, you can bring it to a federal court, but you're operating on the state level. It's our crazy form of government that should get us into our frontal cortex, because it's filled with all sorts of paradoxes and contradictions, et cetera, which is how it was designed, to make it harder to do anything. Because generally when we do something, chances are good we're going to screw it up. So this one kind of law, criminal syndicalism, happening on the states, they all get overturned. And we could say, woohoo! Isn't this great? And yet, who's the guy who made it happen? All right, so this is where, if it was theater, we'd have a little lighting change or whatever, and this whole sense of dark music would come in, and it would turn out, oh my goodness. Let's hear about Clarence Brandenburg. And first what I'm going to do is give you the facts of the case, which you can find in your handy little booklet. We'll go over the facts of the case, and then I'm just curious to see if, before we get into the actual oral arguments and then what the court said, is there anybody here who would defend the plaintiff in this case? You can ask your hearts. Is there anybody here? Yeah. Yeah.
Before I get into the state versus federal, I have a question about how they dealt with it before this.
Yeah.
So, clear
And this is Aiden. Can somebody give Aiden the mic? Thank you.
Hello. Is it working?
Yeah.
It's so good that I can't hear it.
Uh.
Clear and present falsehood. It seems like the hardest, most fecund part of that is, quote, falsehood. And I have a whole story that I'll skip about my brother's professor and this. But in the first case about pamphleteering against the First World War,
Yeah.
for that to be ruled a clear and present falsehood,
And it's danger. That's the one. It's a clear and present danger.
wasn't false a part of it?
Well, Holmes uses that as a metaphor to try and explain the doctrine.
Okay.
But the doctrine itself is just, if this speech presents a clear and present danger, then First Amendment does not protect.
Okay, maybe we can skip this question then. But I'm wondering, because if it's true, I guess it can't be all that dangerous. You'd want people to know the truth, right? So
Right.
in the case of pamphleteering, wouldn't this require the court to somehow litigate the truth of whether or not the First World War is an industrialist plot? And did they do that? Did they ever do anything like that?
I think that's a beautiful question. Could we turn this into a fact question and say, is it a clear and present danger? What is the actual content in the pamphlet? Can we debate it? That's what Brandeis is eventually going to ask for. Let's have a public discussion. But because of the way it's framed in the Schenck decision, what the court ended up saying is, what were the consequences of the speech? If the consequences were a reduction in conscription, that's a clear and present danger. We don't even care about the content. We're not going to have a philosophical discussion. People were being arrested for having Marxist reading groups. It's what is going to be the effect, and it was based on the effect. That's how they determined whether it was dangerous. And that was like the clear and present danger doctrine is it's not a law on the books, it's an approach as people are trying to make sense of these cases that are coming forward. I have a First Amendment freedom. You present a clear and present danger, but I have a First Amendment freedom. And they go back and forth and they say, sorry, clear and present danger, back, you go to the pokey. Yeah,
By that doctrine, would that mean that it would be illegal to yell fire in a theater and people get trampled on the way out, avoiding a real fire?
And that's why Holmes says falsely. But I think, Aiden, what you're doing is you're leaning on this court decision and you're saying, wait, there's a lot of questions here. Because there's one thing about the whole in a theater, especially if somebody is falsely doing it in order to create a panic, and as opposed to a pamphleteer who says, I'm going to create a panic because I think there's a real problem with this First World War. But I don't think it's a false panic. I think people should wake up. But the clear and present danger doctrine creates a situation where there's not a lot of First Amendment freedoms. So I don't mean this disrespectfully, but there's a part of me that's now going to have to say, thank goodness for Clarence Brandenburg and the Ohio Ku Klux Klan. This is the only instance in which I'm going to make this case. But right now, that's the case that's going to undermine this whole idea that the state can pass criminal syndicalism. So, is there any other questions before we get to the facts of this case?
Yes, Meg.
Yes.
Could you please, what is the word syndicalism? I've never heard it before.
Yeah.
And I looked for a dictionary over there, but I couldn't find it.
Right. So that's a great question. What's your name? Anne. So, syndicalism. Anybody know? To be a syndicate, to be part of a syndicate. To be part of what? Like an organized group. Yeah. It's something, it's not a formal organization. It can be super informal. And it may have conspiracy or not. It just says, it's the language of the statute is anybody who is advocating the duty, necessity, or propriety of crime, sabotage, violence, or unlawful methods of terrorism of a means of accomplishing industrial or political reform. Any group of people who is engaged in this kind of an activity, it's kind of like the RICO statute. By association, you can get pulled in. And Shoshana is saying that syndicalism was used against unions. And you can see why. Doesn't this language say you're looking for industrial reform, you're gathering with other people, maybe you consider a strike. Would that be considered violent? Just for participating in this, you could be put in jail under these state statutes. So it's very, 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 very broad. Okay, so a lot of people are wanting to get rid of these. Yes, Scott.
In regards to the first case, it says that that what is a threat is if any substantive evils that the government has a right to prevent. I'll repeat. It's on the first part of constraints on free speech. The question in every case is whether the words used in such a circumstance and are of such a nature as to create a clear and present danger that they will bring about the substantive evils that the government has a right to prevent. Yeah. I remember when you introduced a Galbraith lecture, you mentioned how one of the tenets of the formation of the United States is the right to an insurrection or to remove the government.
Yeah.
How is this a contradiction of that, if it is, and what you introduced before the Galbraith lecture, what was it, 2 years ago?
Well, thank you, Scott. So I was talking about the Declaration of Independence, fundamental right. It is the right of the people to alter or abolish any government that does not respect consent of the governed, liberty and equality, all those things. So we have it in the right of revolution. And yet, this clear and present danger, again, Oliver Wendell Holmes has done a lot of wonderful things. He's a very smart guy. But was he really thinking about what the whole political experiment allowed? No. Yeah. So maybe we're going to be happy about what Clarence Brandenburg was able to do because he restores the right to revolution. Yeah, in the back.
I just wanted to mention that there is no right to insurrection written into the Constitution.
Not into the Constitution, right. In the Declaration of Independence, that we have under certain circumstances, we have the right to alter or abolish. But we have to organize ourselves, and then immediately after they say it, they say the next thing in the Declaration, and to institute a new government that to us, founding it on such principles and organizing its powers in such a way as to them seems most likely to affect their safety and happiness. But your point in the back, can you just tell us your name? Robert? So the Constitution does say you have a right to put down domestic insurrections, Article 4. But there is an interesting contradiction here about the government saying if they think it's an evil under the clear and present danger, they can stop it. And then Brandeis saying later, how about we first talk about it and stop putting people in the pokey? Yeah, David.
I was just going to add that in the Constitution, we do have the phrase redress grievances, or petition for grievance. But there's no indication of who you deliver this petition to.
Yeah, right. So First Amendment, right, exactly. We've got the right to petition the government for redress of grievances, and we get to do it after we've had an assembly. So our whole First Amendment should set us up for doing something, and then we have a discussion. All right, are you ready for this? We're going to take down the criminal syndicalism. We're going to take down clear and present danger. We're going to open up our First Amendment rights again because Clarence Brandenburg, who's a member of the Ohio Ku Klux Klan, is giving a talk like this, except that it's dark, and there's men in robes, and there's tiki lamps, and there's a burning cross, and there's weapons. So it's not like this. And he says, we're not a revengeant organization, but if our president, our Congress, our Supreme Court continues to suppress the white Caucasian race, it's possible that there might have to be some revengeance taken. So he says that. Now, this is 1964. The case is 1969, but in 1964 he says this, June 28th. And he's promoting how the Ku Klux Klan in Ohio has more members than any other organization in Ohio. And this summer, 1964, some of you may remember it, there are some horrible things happening. Civil rights workers from Ohio have been found dead in Mississippi. 3 men, bodies are found. 1 man, the black man, has been tortured. After those bodies are found, Mr. Brandenburg is arrested. Seems reasonable. Seems like clear and present danger. He's a member of a terrorist organization. I don't think many would dispute the Ku Klux Klan as a terrorist organization. They will promote violence for political reform. And so here's this handy-dandy statute, and the problem can be solved. So we'll just put Mr. Clarence Brandenburg in the pokey. He's fined $1,000, and he has a 10-year sentence. But Mr. Brandenburg says, wait a minute, I have a free speech right. And it goes to the Supreme Court. So before we get into like, okay, what did the oral arguments sound like? And who got involved? It's kind of, is there anybody here who would say, all right, I'd go to bat for Mr. Brandenburg? Steve would. Okay, and then we'll go to the back here. Steve, and then can we have it to, we're going to give it to the back, and then we'll come to Steve. Yes.
Hi, my name's Craig Miskovich.
Craig.
It's nice to see you. Yes, we have to defend awful, vile, hateful speech.
Yeah.
Okay, hold it closer.
And,
yes.
and even awful poking with the microphone. Yes. Yeah. Tell us why, Craig. Like, why do we have to take this horrible speech?
The jurisprudence says we have to do it because you don't want any speech restrictions based on the content of the speech.
Yeah.
And you want our government not to be an arbiter of what's good speech,
Yeah.
what's true speech, what's valuable speech.
Right.
You want the government to stay out of the speech qualification game.
Yeah.
And you want to, as we discussed a little earlier, combat bad speech with more speech, not with penalizing horrible, awful, vile speech.
Right, right. So you would be okay. You would say, I'm going to defend Mr. Brandenburg. I don't agree with what he's saying, but this statute is horrible. We got to get rid of that criminal syndicalism statute, and we're going to take it down, and we're going to back him.
I absolutely would. And,
Yeah.
and part of that is because it's in my self-interest to do so. Yeah. Because someday the political winds might change.
Right.
And now my speech that I prize is
Right.
going to be disfavored and
Right.
penalized.
Great.
It's easy to defend speech when you agree with it.
Right.
It is hard to defend it when you detest it.
Got it, got it. So Craig, you would defend him. Steve also is going to weigh in on this, and I got two other people, first Michael and then Aiden.
I'd say two things.
Yeah.
One is that Brandeis very carefully says it depends on if you got time. If there's time to have the discussion before the bomb is thrown, that's consequential.
Yeah.
The other thing I'd say is, as Mr. Brandenburg, you got to connect me with what happened in Mississippi. If those guys that were killed in Mississippi, if the people who killed them never even heard anything about what I said in Ohio, there's no connection.
Yeah, yeah.
And therefore, you can't hold me, you can't putting me in jail is not going to do any good for the situation.
Right, exactly. So here's another defense you could make. It's like, it's got to be imminent. You got to have like this timeliness, and there's better be a connection that establishes this speech created this actual thing. Nichol.
I'm going to get nitpicking, but I have a
Yeah.
request.
Yes.
That with the way you're phrasing the question, you're saying, would you defend Brandenburg? And I
So
think
can
that's
you hold? Yeah, can you hold it there?
The question you asked several times is, would you defend Brandenburg? And I think it's critical, and it cuts to the core of everything here, is would you defend what he's saying? Would you defend as distinct, totally distinct from what would you defend his right to say it? And I'm asking, be more precise in your question, if I may.
Yeah, yeah. So everybody here, Nichol is saying it's not defending his speech, it's defending his right to say it.
And oftentimes, I think that's the point, is oftentimes those are, the only reason I'm picking on this is because that's often exactly where the problem comes down here is the argument, if you're defending Brandenburg, are you defending what he's saying? Are you defending his speech? His right to speak? And I think that needs to be kept clear.
Right, right. And so Michael really wants me to be like clear about what are we saying about who's defending and what does defending mean. Aiden is also waiting, but I just want you to know the ACLU defended Brandenburg. And then we're going to talk about the people who were actually the advocates who defended Brandenburg's. As Michael's saying, not what he's saying, but his right to say it, and advocating for his position that my free speech rights have been violated in front of the Supreme Court. And to imagine getting into their head spaces, because that's kind of, or maybe their heart spaces. That's where we're going to be going. Aiden. Thank you, Mike person.
I might also argue that this sort of speech prohibition is redundant, that maybe we shouldn't be worried about this because things like militia violence are already illegal. And if I'm in the KKK, I and all my co-conspirators already know the theoretical consequences of our actions from the eye of the law. So arbitrating speech in substitute of potential future action might be nonsensical.
So, Aiden, I think this is such an important piece. There could be laws on the books in Ohio that perhaps felons should not have firearms or something. And then you go around and you make sure who is at this rally and could they have a firearm. Or maybe there's some other criminal statute that wouldn't entail speech at all, and that would have been a much smarter way to go. But this statute is all about organizing, speaking, coming together. Yeah. Okay, so it turns out the ACLU is willing to defend Brandenburg's claim that his First Amendment rights were violated. And it's pretty fascinating when you think of what the Ku Klux Klan is saying. So I gave you the nice parts of Mr. Brandenburg's discussion. The not so nice parts have a lot of terrible things to say about black people, using a different word, about Jews, using a different word. And so there's a lot of hateful speech coming out of his mouth. The language that the government could use to put him in the pokey was when he said revengeance having to do with the government. But he's saying all sorts of horrible things. So then the question is kind of, what do the people who decide to defend him, how do they do this? Because it turns out his attorneys, one of them is a Jew. And he is going to be the one who advocates in front of the Supreme Court on behalf of Mr. Brandenburg. I think his name is Alan Green. Does anybody have this card? Who's speaking in front of, I think it may be, who do you? Alan Brown. Okay, sorry, I always do that. Alan Brown. So we have Alan Brown, and I think, Nichol, you also have a card. And you have the attorney for Ohio. Okay, so we're going to have to do this in order. But first, I want to let you just know one other thing. Besides Alan Brown, there is also a second lawyer who's working for Brandenburg. You probably know her. Her name is Eleanor Holmes Norton. She was a civil rights attorney. She went to Antioch. She is currently sitting in Congress. Probably its longest sitting member in the House, anyway, District of Columbia forever and ever and ever. She was a student at Antioch. She interviewed Medgar Evans before he was killed. She understood what the Klan did. She had no naivete about what white supremacy was doing to black people. She was the other lawyer working on this case, Eleanor Holmes Norton. So it's the oral arguments. I just want to sort of set the stage. And first we're going to hear from Ohio, and that's Nichol. So we're going to hear this exchange between the Ohio lawyer for why Ohio is right to have criminal syndicalism statute, because, let's be clear, what the Klan is saying is horrible. And the government has a right to prevent those kind of evils. So that's going to be Ohio's claim. So what does this guy do, Nichol? Well, yeah.
The first is Leonard Kirshner, who's the attorney for Ohio, and he asks, what would happen if someone went down to Harlem and said, bury the Negroes, send them to Africa? To which Justice Thurgood Marshall responds, he wouldn't last very long.
Okay. Everybody hear that? Yeah, let me read it, Nichol, just because, let me read the card. All right. There's the card. Okay. What would happen, can I give this? What would happen, thank you, if someone went down to Harlem and said, bury the blacks, or bury the Negroes, is what he actually said, send them to Africa? He's saying that in front of the justices. And he's looking at Justice Thurgood Marshall, the only black man at the court on that time. And Justice Thurgood Marshall says, he wouldn't last very long, and everybody in the courtroom laughs. And at that point, everybody thinks Ohio just won. He wouldn't last very long. Why should somebody be able to say that in Ohio? They shouldn't last very long. We should put them in the pokey. That makes sense. Everybody's laughing, and they're thinking Thurgood Marshall is with Ohio. Then, Scott, what comes next?
Alan Brown, the ACLU attorney for Brandenburg, says, Justice Marshall is safe for the moment because the venue is Washington, D.C. But in Ohio, he could have been indicted for suggesting a violent reaction from the black community.
Whoa! Is that not nice? Phil says nice. It's Phil, right? Yeah, he says nice. Because, whoa! Everybody in the courtroom is sure that Ohio's going to win. And this was the case everybody hoped would restore First Amendment rights and get rid of the syndicalism. And yet that was such a smart move of Mr. Kravitz from Ohio that, and then it all gets turned around. And it goes back to Craig's, like, who is the government? The government can't be the arbiter. We don't want the government having this much power. So let's read in our pamphlet what the court says after that interesting little exchange. I didn't quote lots from it. It's basically, this is on the right-hand side. You can see all the justices at the time. There's Thurgood Marshall up there in the upper right-hand corner. The mere abstract teaching of the moral propriety or even moral necessity for a resort to force and violence is not the same as preparing a group for violent action and steeling it to such action. You want to talk about Marx? Talk about Marx. You want to talk about armed revolution? Talk about armed revolution. You even want to talk about a group of very disgruntled white people in Ohio in which they say, if they're going to suppress the Caucasians, we're going to do something about it. You should be able to say that. Statutes affecting the right of assembly, and this is the other piece of that Marnie read to us. It's not just speech, it's also assembly. Statutes affecting the right of assembly, like those touching on freedom of speech, must observe the established distinctions between mere advocacy and incitement to imminent lawless action. It's not clear and present danger, it's imminent lawless action. So if you're charged with something, the government has got a high bar now. It has to prove that the speech itself led imminently and direct action that was lawless. So the government was in a much more difficult situation with this. Big win. Still, what do we think? That's the speech? That's the racist bullshit that gave us better First Amendment protections? Yeah, it did. So Eleanor Holmes Norton, I just think she's amazing. And I know some people have cards. Does somebody have a short card of what she said? Yes, could you, and can you remind me your name? Cynthia. Yes. Thanks, Allison.
Thank you. I was only in this for the principles involved. In these circumstances, self-interest becomes an absurdity.
Yeah, I was only in this. She's defending. She's doing all this homework. She is trying to figure out, like, why am I doing this? I'm only in this, she says in an interview, for the principles involved. Self-interest. Black woman, worked in the civil rights movement, knows exactly the brutality, the cruelty. Self-interest under these circumstances, she said, is an absurdity. I feel like that's a heart talk. That's like really focusing on your heart and saying, yeah, I may have all this self-interest. Like, I want this guy down. I'm going to feel a lot better if this guy's in prison. And yet, I can't do that. My self-interest is an absurdity. And then she said something else a decade or so later.
No society continues to grow without its own powerful myths. The myth of the Constitution is the handiwork of black people. When there was nothing but racism, they believed those words. Because they believed them, they ultimately made them live.
Because, can you say the last part?
Because they believed them, they ultimately made them live.
They made, yes. Live. The myth of the Constitution is the handiwork of black people. When racism was everywhere, we believed, I'll say it as if I'm Eleanor Holmes Norton, we believed in them so much that we made them live. That's her principles. We hold these truths, and we're going to go with these principles, and I'm going to defend this cracker. I don't know. What do I say about Mr. Brandenburg? I'm going to defend him because this is how I am going to have more freedom. It's quite a statement. Yeah. Steve.
That is self-interest.
And it's self-interest.
In the long run,
yeah,
that is, I mean, I think Aiden said that before, that in the long run,
yeah,
that is my self-interest because things might change.
Right. Yeah, things might change.
So it isn't not self-interested.
I'm just quoting her. You can take it up with her because she's still in D.C. You can go say to her, knock, knock, knock. I actually think, yeah, good, he's on his way.
It's collective self-interest.
It's collective self-interest. I don't know. It's very confusing, isn't it? I mean, that's why I've come to this idea you have to polish your heart in order to do this. So I got one other card, and then I'll go to Aiden because, let's see. Aiden, you'll go first, and then we'll get the mic for the last card.
So it used to be that the Supreme Court was very concerned whenever it would change the standard for something that the court had already ruled on in the past. And we started with a history lesson on Justice Oliver Wendell Holmes and that court's opinion of what the standard should be for free speech. Did this new standard in its commentary include any direct references to why they thought the previous version was wrong? I can imagine Oliver Wendell Holmes saying this is exactly what I meant by a clear and present danger. What you call stealing, stealing the forces for violence or whatever, what is that but speech?
Yeah. Excellent. This is so perfect. They did not overthrow Schenck with Brandenburg. Schenck is not overthrown. We may have more clarity about what clear and present danger is, and it may be harder for the government now to prove clear and present danger. So clear. I'm so glad you asked this question. Whitney was overruled with the Brandenburg. So that decision in Whitney made it so what Charlotte went through should never have happened, and those kind of laws got thrown out all over the country. So all those syndicalism laws, they got thrown out. So does that answer the question? Like, it didn't completely overthrow, they didn't overthrow Schenck, because I think you're absolutely right. Clear and present danger is really, really broad, and governments could use it quite effectively to put people in jail. This new standard, and the former president is using the Brandenburg case in his defense around the insurrection charges on January 6th because the bar for the government is higher. But I also want to go back to this heart, because boy, do I feel like, and I'm wrapping it up now, I feel like so much about politics now, I said I was hoping we could go to the frontal cortex. I'm beginning to think we really have to be polishing our hearts. And if we are going to take these principles seriously, that's where it needs to happen. So I quoted St. Thomas Aquinas, I quoted a Sufi reference, but we have Judge Learned Hand with us, and maybe you could channel what Judge Learned Hand
Give it a
said.
shot. Liberty lies in the hearts of men and women. When it dies there, no constitution, no law, no court can even do much to help it. Judge Leonard Hand, 1944.
Liberty lies in the hearts of men and women. When we get rid of it there, the judges can't help us, the courts can't help us. If we're not really taking this seriously, it'll go back to Eugene Debs in jail, Charlotte Whitney in jail, all these other. If we don't have it there, the courts can't help us. Yes, Lisa. So what became of Brandenburg's heart? Listen, Lisa asked that question. I feel like that's the key. It's a very big question.
Did he thank her?
Well, you know, I have a play in my mind. Maybe Steve's going to write it. I have this play in my mind, or an opera. And so you imagine, here's Mr. Clarence Brandenburg in jail, and he hears that the Supreme Court is going to take his case. And the lawyers come in to talk to him in the cell. And one of the lawyers is Alan Brown, or is it Green? Brown. Sorry. Brown. Alan Brown. And Alan Brown comes in, and he starts to talk about Brandenburg and the strategy he's going to use. And Brandenburg can't help but notice he's a Jew. And then Eleanor Holmes Norton comes in, and she is talking to him. This is the strategy I'm going to use. This is how we're doing this. We really want to get rid of these criminal syndicalism cases. And then what does he do? In my imagination, or in Steve's play, which I'm sure going to write, all of a sudden, there's like this whole thing starts to happen. How could it not? So I got to believe that something happened to Mr. Brandenburg's heart. And my last piece, I'm just going to, and then I'll open it up for all questions. When I was trying to figure out what Eleanor Holmes Norton, like what are these principles? Is it just First Amendment? Is it just free speech? Because those are fairly abstract. Well, these are the principles that Bayard Rustin lived by, civil rights architect, leader, amazing guy, Quaker. And he had 5 principles. 1, nonviolent tactics. So whatever you're doing, again, this is like polishing your heart. If you're feeling the urge for violence, just start polishing. You got to do nonviolence. And that's going to be essential. Number 2, constitutional principles. Take these freedoms seriously. Freedom of assembly, take it seriously. Petition the government for redress of grievances, take that seriously. We have that right. Democratic practices, that to me is talking to each other. Like having a forum like this, hearing different points of view. We're not all going to agree on the First Amendment and what it should be about. But maybe we don't need to put each other in the pokey or call the government to put us in the pokey. Maybe we can have a conversation. So really democratic. Number 4, respect for the human personality. Even Mr. Brandenburg's? Like what's his backstory? I guess he was a TV repair guy. Things must have been rough. Cincinnati, I don't know. But you have some respect for the human personality and that we all have these feelings inside. And finally, this is the big one, belief that all people are one. Must be like Ku Klux Klan inside me. There must be former president inside me. There must be all these different things inside me. What's that great line from Terence? Marx put it on his tombstone. I am human. Nothing human is alien to me. So, yeah, I feel like this is the polishing we need to do in our heart, take our liberties, and have a good time. So that's what I got, and I'm open to any conversations or whatever. Questions? Yes, Seth. Yeah.
I find myself concerned about one thing.
Yeah, good.
Going back to Oliver Wendell Holmes' first quote, the character of every act depends upon the circumstances in which it is done. What about the character of the court itself?
And what are you getting at, Seth? Like, what is the character of the court?
Well, if the judgment of the court is being swayed by the things that they're judging, that are the judgments before them,
yeah,
how are they trustworthy
yeah,
to be independent arbiters?
Right. And this is a big question that we have it right now, but the Supreme Court, how, if I'm hearing your question right, who is judging the Supreme Court? Right?
That's my question.
The question is, who is judging the Supreme Court?
Do we need a fourth branch of government?
I think we have it. I think it's called We the People. I think we are the ones who should be reading these decisions. Personally, I'm very unhappy with the headlines. I think a lot of headlines are very misleading right now and are getting people much more upset than they actually need to be. If you want to read, there's 2 great books out. One by Justice Ketanji Jackson, which describes her childhood and what it was like to get on the court, and she is so in love with the Supreme Court, and she was so excited to be there. So it's a very moving story. I also highly recommend Justice Gorsuch has a new book out. It's amazing of these stories of people who've gotten caught up in stupid laws. I point to Aiden just because you were talking about, we got too many laws out there. Stories like Aaron Schwartz, maybe you remember that young man who took his life, who the FBI was going after because he was downloading JSTOR articles, and it was a relentless prosecution. So he's looking at cases in which people's lives were destroyed because their very basic protections in the Constitution were not given to them. And so that's Justice Gorsuch's new book about how we've got too many laws on the books, and we should pay a lot more attention to our freedoms, and he quotes Justice Learned Hand about liberty in the heart. So I actually think we the people, if we just get our hearts, and then we look at a certain decision and we think, well, maybe I don't like that one. But why? Where did it go wrong? What is it you would like to see instead? Or is there something in a dissent that you find more compelling? Is there a way to imagine a case that might bring that forward so that we don't just surrender all this liberty-loving, liberty-protecting to the court? Yeah, so that's my big like. This should be a people's movement. Scott. Sorry, Aiden, I gotta, if there's, and I'm looking for a couple of people, we have to stop in like 5 minutes or so, so I'm gonna go to Ann, is that what? After Scott.
I don't have a point of view. It's just simply a question that I think brings a lot of these issues together. And that is, say, social media, what was Twitter, what was public health, how public health was contested, sometimes rightfully, sometimes conspiratorially and falsely, but also rightly. Yeah, just basically how do people feel about someone like Elon Musk, who is leaning more towards freedom of speech, even in regards to public health, which is contested. But it also can really, it was a pandemic, it does present an immediate present danger to the entire nation.
Yeah.
I think that type of issue just brings in everything all at once.
Yeah, well, I think we're going to see lots of cases, and we currently are seeing lots of cases, trying to figure out what sort of action resulted in an imminent lawless action. You're going to have to connect those dots. So, and some of this around social media, I'm not sure how they're going to be able to connect all those dots. And how does imminent work in asynchronous time? I don't know. It's very confusing. I can only help us with polishing our hearts. Just keep polishing. Yeah, and then Shoshana.
I'm curious to know under the Clarence Brandenburg when he said we're not a revengeant organization, but if our president, our Congress, our Supreme Court, this is my question, continues to suppress the white Caucasian race, what evidence, what facts was that based on?
So that would be Brown versus Board of Education. That would be all the other cases around that, and there's a whole constellation that had to do with law schools, et cetera. There were also changes to Jim Crow laws on the federal level. The court ruled that interstate travel on buses and trains could no longer be segregated, so that undermined Jim Crow. So the Supreme Court and the NAACP, legal defense, were doing a lot to open up rights for African Americans. And then Congress, through the Civil Rights Act of 1964, so it's about this time, is also creating all sorts of programs. So you have Johnson's in the White House, right? So Johnson, Congress that's passing the Civil Rights Act, and a very, very active Supreme Court, and that's what he's talking about. So a major step forward in terms of civil rights. Correct. Right. Yeah. So they read that as a loss. Yeah. Yep. Shoshana.
So my question has to do with the comment made just before this last one with private, this social media.
Yeah.
I'm not even on it. I don't even have a computer, but I hear lots about it. And there is an ongoing discussion about censorship.
Right.
And I'm just wondering, you as the constitutional wrangler, can one, in whatever side people are arguing within the social media thing, does the Constitution even pertain? Because the Constitution's about what the government has a right to do.
Right.
And, I mean, for the most part, our private companies, our industries, our bosses, et cetera, they can do whatever they damn well please.
Exactly.
And so I'm just wondering about this free speech argument that is going on in a very general way.
Right.
How does it tie in with our rights?
And these are the cases that the Supreme Court keeps saying, well, we're about to try and figure it out, and they haven't. From people who know a whole lot more about this than I do, who are studying moderators on these private platforms, that there are some useful decisions being made about what content can stay on and what can't. So Facebook, I gather, has set up this panel of people who make decisions of what can be on and what can't be on. They seem to be using more policies coming from the European Union because, as you say, the Constitution is all about government action, and that there are some good policies being developed to do content moderation. I don't know. But this is a whole private thing, and the more people are using it, who's deciding it? Are there any freedoms available to people? Is there a redress? Can you go through a grievance? You know, are we going to give up on the public sphere and do all our communicating online? I hope not. I feel like this is the place where we have a chance to put the Constitution into practice, and nobody can quite figure it out on social media. So maybe if we're going to hold those two realities, please give as much time to the public space, face-to-face, talking to people, actually being with each other. So I'm very conscious of the time, and when the library closes at 8, I'll stick around for a little bit. So, Star, I'm going to turn it back to you.
So actually, the library closes at 9.
Oh, okay. Why did I think 8?
I don't know.
Sorry.
But, so do feel free, hang out, talk to one another, talk to Meg, talk to me. But let's have a nice conversation. And thank you so much, Meg. And to everybody else, pick out a banned book to take home and read.
Okay.
All right.
All right. Thank you.